So I have clarified, my lord, within
This court will inform that there are certain other
those who are qualified MPhil, my lord.
who are claiming exemption from UGC, who claim that there are specific exemptions granted by UGC in respect to the aforesaid qualifications. So, needless to state that if there are that UGC has exempted certain category of persons from the applicability of the aforesaid regulations. The said exemption, if any, would this interim order will not affect this exemption. Here you want to plead.
My lords, if I may be permitted, my lords, it is not so easy for these petitioners to register for PhD, my lords, or to appear in these examination. The passing rates are very less, my lords. It's not that they have not tried at all, my lords. They've been trying.
There are candidates who have crossed this examination. If they're available, then the students will have the benefit of those. There is an expert body that has framed these regulations.
The state will have to take some policy decision for the number of years they have served here, my lords.
Policy decision is a student should get the best education.
It's not that we are not teaching, my lords.
So if some threshold has been fixed by the UGC, that has to be crossed.
Last year also they did not conduct any counseling. They have been continued. Therefore, the state requested, please continue for another year.
Our hands are bound by the law. Unless we come to
that is why we wanted to demonstrate before the
UGC do not apply. We can't help.
No, we are.
It's not available for us to alter the statutory regulations on even if you are persuaded to. So all we can do is give some sympathies, but we can't give you an order. So
that is why we wanted to request before the court to give an opportunity of hearing.
We hear you.
Till it is been decided.
As far as this academic year is concerned, this interim order, we'll hear you on that.
So that
if you are,
they will be out of service. They will be out of service. The persons who have been taught for now, all of a sudden, the persons who have taught for 20 years, now they have been said you are not qualified.
This service is not a regular service.
Yes.
You've been appointed year to year.
That is Manish Gupta's case. Your lordships are aware. The Supreme Court in a guest faculty's case only have held, unless the regular recruitment is there, you cannot be disturbed. You have been continued.
Also, one set of guest lecturers cannot be replaced
by another set of guest faculty. Faculties is also there. But if this order is being given effect to by the state government,
It will be.
Faculty they have to appoint, no?
That is why we requested a kindly continuous which have been continued earlier, and hear us, and another for 2 months or 3 months, so that the pleadings will be completed. We will address our arguments.
It has to be done in August. Milords academic year is started. Now, Milords, it is the right.
Previous also year they have taught. Now they continued. The persons who did not. That is the problem.
No, Milords, the latest regular we appointed 1,400 people.
There are the total number is some 10,000 and 7,000 is regularly appointed lecturers. 3,000 may be fluctuating because of various new courses or such kind of or absence of the students at some particular places. But that cannot be 2,000, 10,000.
In affidavit, increase in strength and other things.
10,000 is only regular.
We'll hear you on your point if you want.
Yes,
but not flawed. But that's post interim order because we don't find any primary.
We are also requesting the court. Your lordships now have exempted the subjects in which the qualifications are not there. Not there. We have also standing on a similar footing where we have been extended from last 15 years.
Where there is no eligible candidate, obviously they will still have to run the point. You're not
Therefore-
eligible candidates being there who are not being appointed because you are employed there. That's the issue. But you tell us, we'll hear you also.
It is not the case where there is a scarcity. They have been,
We can't hear arguments in this manner.
Yes.
You have a point
yes,
to make on this. You make the point, we'll hear you. This order will stay. Sustain till.
All impleading applications intervening could be allowed so that if they have
That's
to make a
right.
point, let
We'll
them.
allow this.
Please.
but let them not disturb our,
No, that's not correct. Except there are
Before this,
a large number of
they may be protected by law.
even before the learned single judge.
large, just give us the implement application that you file. We'll allow. We can't hear 20 applications. No? You'll have to demarcate on who are the existing ones, who are not going to be heard. We can't hear 20 councils on an implement.
So I think the main impleading applications were filed by UGC qualified candidates who are on the other side. Maybe now that their interest is protected, I think their
The-
I number 18, your lordships.
Also, UGC candidates who are then we are accepting that prima facie. So you can watch these proceedings. If anything adverse order comes to be passed, then you can look
Please,
Should
your
all the applications be listed, Manoj, on some other
at
date?
all of the applications will be listed on, give a date, list on dash for further proceedings. All applications for implement and intervention be also listed the next day. Or just list for further proceedings, full stop. The endeavor would also be made to hear the parties seeking implement or intervention, public intervention in the present appeal.
We are also requesting one more request, my lord. The contentions which you have, your lordships now dealt with, that contention which you have sought to be reviewed may be kept open so that we will also address, if it is that reviewed,
An interim order, that's why we have placed it in interim order. The appellant also wants to.
because the kindly see a situation where the interim order is, division bench's interim order is placed before the learned single judge. But he will say nothing to consider, it has been modified.
We understand, that's why we are saying you want to argue anything, we'll give you full opportunity to argue. You can't say that
We are not.
no, you are not arguing here, but we must now protect you on grounds that we don't agree. As the prima facie agree. If you persuade us, we'll pass a final order. We are yet to pass a final order in this appeal.
Next week, your last minute tentative will fix it so that our rights will be crystallized.
We'll give you a date. This has been put urgently for the mentioning by the learned counsel. But the counseling is happening today. That's why give it 2 weeks time. You make your written note with whatever authorities you want to rely on. Be ready.
8th of October.
Parties are at liberty to file a short note of submissions, propositions along with the
List of site authorities.
along with all the list of relevant authorities. It's the council. Don't say council.
Grateful.